Namaste, good morning. Welcome to 105th episode of AAA Weekly Webinar Series. Today, we are deliberating on project-wise insolvency in real estate companies. If you recall, last week, we deliberated on the reverse insolvency for real estate companies. Incidentally, that was done in a golf course because I was playing golf at that time. So in between the golf game, that particular webinar was done. Now, it's a similar subject. The real estate companies are facing difficulties in resolution. The reasons may be that there are many projects under one company, or secondly, there is one project in 2 or 3 companies. So the project-wise insolvency is a concept in both ways. In case one company is handling multiple projects, then the insolvency should be started only for the one project. If 2 or 3 companies are handling insolvency of one project, then all the 3 companies should be under the insolvency for resolving one project. Now the project is also defined under RERA, that this is what is a project under RERA. So therefore, even if there are one project where 2 or 3 phases are being developed, and the RERA registration is taken for different phases, then for filing even application under Section 7, the project would be considered as one project as registered under RERA. So we would require either 100 allottees or 10% of the total allottees for filing an application under Section 7. So today, all this concept of project-wise insolvency, very clearly both ways. If one company is handling multiple projects, then only one project would be under insolvency. And in case there are multiple companies handling one project, then all the multiple companies will actually be initiated for insolvency. So this two-way, the focus is on the project. The focus is on the resolving of the project. However, in case of a company where are more than 60-70% projects are under default, then probably this concept will not work. Then the entire company will be resolved collectively. Yes, there is a possibility that even if there is an entire company under insolvency, one project is under default, 2 is default, 3 is default, 4 is default, but 1 is not under default, then still the project-wise resolution plan can be asked from the public at large. The regulations have been changed. Now, coming to the basics of the project-wise insolvency, today we are going to discuss what is the concept of project-wise insolvency. Then we are discussing various judicial pronouncements and also the practical difficulty that has been faced. So the concept came when the judiciary found, first of all, it is very important to understand that there is no such concept of project-wise insolvency under IBC. It is only and only on in the month of February. In the month of February, on 15th of February, 2 regulations were added in CIRP regulations. One regulation was Regulation 4D, which actually only requires that the RP will open project-wise bank account during CIRP of a real estate company. And the second amendment was made in Regulation 36A, where it was now permitted to the RP, with the permission of the Committee of Creditors, that the RP can invite resolution plans for each real estate project, even if the project, there are multiple projects. Therefore, this is what is the concept, that yes, there are possibilities that the 5 projects of a company are near completion, 90% completion has been done, and those home buyers are not interested to file their claim. They are very positive that they will get the possession within the next 2-3 months. and the promoters are also very, very hopeful. Then there are some projects where like most of the people are already staying, but some of the flats are not handed over. Some of the common facilities are not made. So all these people who are already staying there, they are also having some obligation towards the company. The company is having some obligation towards them. They are also not supposed to file their claims. So when these hardships were seen, first time the Justice S.J. Mukhopadhyay, the chairman of NCL 80, in fact, he started this innovative concept of project-wise insolvency. And the various subject that was discussed in various judgments, like what are the objectives of project-wise insolvency? One, that only those home buyers will suffer who are actually suffering from the delay or other issues. Anyone who has already almost on schedule will not suffer. Even there is a small variation in their agreement and the actual schedule of delivery, still they would like to cooperate with the promoter and they would like the company to focus on those projects. The value maximization is also possible in case the resolution plans are invited project-wise. Now, the engagement of the stakeholders, like in one project, there can be a project-wise COC also. There can be a kind of, see, the focus is on the project. Although there are practical difficulties, the risk management also has to be seen. But then the benefits that we have seen so far is that the other projects can continue to perform, the construction can continue, the RP will not have control on those projects. Then the promoters, the corporate debtor, will focus on those projects which are not in default, and they will be protected from various litigations and enforcements under the moratorium under Section 14. Although this is also a confusion whether the moratorium would be available for the company as a whole or the moratorium would be available only for that project. The home buyers for the well-performing projects, they will not be required to submit their claims. They will get their possession. The court will monitor the the project very carefully and focusful. The supervision of the RP on one project would also be better. Separate bank accounts will be opened. So therefore, in those companies where some of the projects are not getting implemented because of the reasons beyond the control of the promoters, some natural calamities, some change of law, some government authorities delay, or any such event, so they may happen, and one project is somehow under difficulty. So if the one project is under difficulty, the entire company can still be continued, can still hand over the possession to the allottees. So when this recently this concept has also been kind of accepted by the government by way of regulations. So the challenges that we are facing as an RP in project-wise insolvency. One is that the tracing of the assets of a particular project is difficult. We are not sure what is the inventory, not exactly the real estate inventory, but the other inventory, like various construction material, various equipment which is required for construction, various other loans and advances given. So all this is difficult to trace and bifurcate between project to project. There are many common assets with a company, and those common assets can be huge, maybe a lot of vehicles or grains or equipment. So it is not really possible to understand what are the assets of this project. Then is there will be a lack of transparency in the accounting. The promoters may like that more liabilities will shift to this project and more assets are shifted to other projects. That also can be done easily by the promoters. Then like there is a trend that all the new projects will be taken up in a special purpose vehicle. So when the SPVs are being made, for special purpose vehicles, then of course that particular company only will be under insolvency, whereas the holding company has taken the money. So those concepts are also very, very confusing. The then it is also sometimes criticized that the project-wise insolvency is a benefit that is extended to the promoters of the company. One, that the promoters will have total control on other projects. The obligation to keep the other projects as a going concern is on them. They will control the fund flow of the other projects. They, however, will also enjoy the moratorium. The moratorium on the company as a whole, so far, the moratorium, although there is a judgment which says that the moratorium will be restricted to that project, but then there are common liabilities, there are common loans, there are common operational creditors, there are common workmen, there are common employees, there are common rent obligations because of the various corporate offices of the company. So all these are common. So all these are basically, whenever there is a commonality, that actually means that the moratorium is extended to them. At least one part is under this project. So therefore, it is considered that the project-wise insolvency is a real benefit to the promoters. So they actually will enjoy the moratorium. They will also get relief from RERA. They will also get relief from NCDRC and also from various litigations with the operational creditors, workmen, employees. Because see, it will be almost very difficult for any other court to decide whether the moratorium is on this or this. Simply, they will see the order, and it's kind of time-taking and very confusing concept, like whether this moratorium is on this liability, whether this moratorium is on this litigation, whether this moratorium is only this to this essential services. So that actually is a very difficult. So now let us see how this concept started. Again, this concept started when NCLAT passed an order in the name of Flat Buyers Association, Winter Hill versus Umang Realtek Private Limited. Again, I said that Justice S.J. Mukhopadhyay and Justice Bansilal, but this particular judgment have also got the confirmation, or it was also upheld in another judgment that was Asset Reconstruction Company India Limited versus Dagcon India Private Limited. Dagcon India Private Limited is handled by one designated partner of AAA Insolvency at Kolkata. So this particular judgment, in fact, was instrumental in getting this concept of project-wise insolvency completely upheld by the Honorable Supreme Court. So in the case of Umang Realtek Private Limited, the appeal was filed before the NCLAT on the grounds of when the CIP was initiated, and it was causing difficulties to other project, which is a Winter Hill. The Winter Hill project home buyers, they approached that we are suffered, we want to remain outside the CIP process. The promoters also came forward. The promoters said that I will complete this project of Winter Hill. It is already near completion. I will contribute additional fund as a third party, and in that case, I will also associate with a financer. The only thing that I need, that one, that this insolvency or this project should be excluded. So that means the project insolvency was also first time it was kind of innovated in this case among Realities Limited, and also the whatever contribution will be done, that should be considered as the interim finance. So that was the first judgment on the project-wise insolvency and the reverse insolvency. So that one project is excluded and the other project is under insolvency. Two, that one project which is excluded will be resolved by way of a reverse insolvency. So the two concepts came out of this Umang reality, and of course now this judgment is very old, most of us knows it, and it was held that this project, it is a project-wise insolvency, one project is outside CIRP, whereas that project will be resolved by way of a reverse insolvency. So then the larger confirmation from Honorable Supreme Court was seen in the case of Supertech Limited. And the citation of that particular case is India Bulls Asset Reconstruction Company Limited versus Ram Kishore Arora, who is the director of this Supertech Limited. And this judgment came in May 2023 and from Honorable Supreme Court. So in this case also, the financial creditor, like the Union Bank of India and India Bull, they actually had gone to Supreme Court and filed an appeal before Supreme Court that they are not really convinced with the project-wise insolvency. They they have filed the insolvency for the entire company, and their arguments was that we have to take loan from the company. The entire company is responsible for this, and although the project was given for a particular loan, but the entire company was responsible for this. And then finally they were saying that there is no power with the NCLT under the law to direct the insolvency for only one project, and all other projects are excluded from the insolvency. In the absence of the power, how the resolution plan, which is submitted by the promoters, saying that how they will resolve the other projects, and the insolvency should be restricted to only one project. How this kind of proposal be accepted by the resolution by the NCLAT, because this company was not even MSME, and this is something which is a contravention of violation of Section 29A of the IBC. So that was the kind of arguments by Union Bank of India and ARCEL. Now, the Supreme Court said in this case that the directions were given basically only for the insolvency of Eco Village project, and that directions, like they didn't want to interfere in these directions. And the court also displayed their concern over the causing hardships to various home buyers who are not kind of suffering, and they are near to satisfaction. So the promoters should be given a chance to work hard and give them their possessions. Their role would be like again the same with some new rights, and they never wanted to pass, the Supreme Court never wanted to pass an interim order for constitution of committee of creditors, and the project-wise insolvency was upheld in this particular case. Now coming to another judgment, which is the Whispering Tower Flat Owners Welfare Association versus Abhay Narayan Manudane, the resolution professional for HDIL, Housing Development and Infrastructure Limited. This judgment came in 2022. In fact, as a matter of fact, what happened is that the company could not be resolved within the CIRP period, and then an application was filed with the approval of the Committee of Creditors, that since there is no resolution plan which is acceptable, so now we would like to go for the project-wise resolution. Project-wise resolution should be allowed to us, and another 330 days period should be allowed to us. That application was rejected by the adjudicating authority by saying that already the company has completed 330 days, and it is not possible for me to kind of extend it for another 330 days. So it was declined by the adjudicating authority. So in this, before NCLAT, the resolution professional argued that there are 8 projects of this company. We would like to invite resolution plans for 8 projects. We have some of the offers in hand for projects. We would like to resolve this company rather than sending this company to liquidation. There are some assets which are not being resolved, so therefore for that particular asset, the liquidation application will also be filed. So this kind of application was filed before the NCLAT, and the NCLAT said that the COC's wisdom, commercial wisdom, is definitely have weight, and they have rightly taken a decision to dissolve the company. Therefore, even if there is no provision for project-wise insolvency, the objective of this particular application is to resolve. Therefore, the rejection of extension of time was dismissed, and 90 days were given to the resolution professional to go back and resolve this company project-wise. And finally, as I understand, finally what has happened is that out of the 8 projects, probably 5 were resolved, 5 resolution plans were submitted, and the rest of the projects were actually liquidation applications were also filed. So this is another kind of project-wise insolvency, where after the completion of almost maybe 400 or more than 400 days, a separate application was submitted that now we would like to resolve it project-wise. So this is another kind of innovation, that once the resolution plan is not found for the entire HDIL, then in this case, the project-wise insolvency is trying to be found. Now we see another judgment from Honorable NCLAT. That is, the name of the judgment is Pankaj Mehta versus Ansal High-Tech Township Limited. The corporate debtor is also Ansal High-Tech Township Limited. This judgment came in April 24, 1st April 24, very, very latest judgment. And this has actually come from Justice Venugopal and Ashok Gupta. Now, in this case, there are various townships in this Ansal company, various apartments, plots, and fairway apartments, residential units. So there are many such projects. The projects are subject to separate RERA registrations, and the in a proceeding like the petitions were in fact filed for the insolvency of this company, but NCLT dismissed that petition. NCLT dismissed that petition that it is contravening Section 7, because which requires either 10% of allottees of a project or 100 allottees of a project. So it was not fulfilling that condition, so it was in fact dismissed. Now, before the appellate authority, before the NCLAT, what was argued by the applicant? They're saying that the kind of interpretation of the adjudicating authority is incorrect, and that each RERA registration is one project. That should not be seen. In fact, the promoters have taken in one particular piece of land, the promoters have taken various RERA registration, maybe separate for plotted, separate for the high rise, separate for villas and row houses. So that kind of different licenses were taken, even separate for phases. So in this case, the company in fact had argued that this Section 7 condition is not complied with. So therefore, in this scenario, the decision of the NCLAT was very clear. NCLAT said that it is very clearly written in Section 7 that one project means a project registered with RERA. So it cannot be possible that we can collect 2 or 3 RERA registered projects and then try to comply with the condition of Section 7, that is either 10% of the allottee or 100 allottee. So that was held by the NCLAT that it has to be from one RERA registered project. 2 or 3 RERA registered projects cannot be collected together to comply with 10% or 100 allottees. So that is also, that's something which is clear, that the project is what is registered with RERA. Project is defined as a project what is registered in RERA. So in the case of project insolvency also, one project which is registered with RERA separately can be resolved separately. So this is also clarified, like what is a project. Then coming to another case, which is Ambika Prasad Sharma, erstwhile director of Horizon Buildcon Private Limited versus the Horizon Buildcon Private Limited. The company is also Horizon Buildcon Corporate Data. The judgment is 2020 and it is from Justice Bansilal Bhatt and Dr. Ashok Kumar Mishra and Ms. Shrisha Vatla. Now, in this case, we are now first time we are talking about the other part of the project-wise insolvency. Now, what is the other part of the project-wise insolvency? That one project somehow is being handled by 2 or 3 companies. So far we have handled that one company is having projects, multiple projects. Now we are saying that one project is handled by multiple companies. So let us see the facts of this case first, the first time. So Horizon Buildcon and Kaveri Sahkari Awas Simati, they entered into a collaboration agreement for a residential project. Then the Horizon Buildcon assigned the rights and liabilities for marketing of the sale to Horizon Concept Private Limited. So basically 3 things. One is the Horizon Buildcon Private Limited, maybe the landowner or maybe the license holder. Then is the collaborator like the Kaveri Sahkari Awas Samati. Then the Horizon Concept Private Limited, where all the rights and obligations of marketing has been assigned completely. So the marketing agreement is separate, collaboration agreement is separate, and everyone is having some share in the constructed space. All the 3 parties are having some space in the constructed space. So Horizon Buildcon Private Limited is also having some entitlement of the constructed space. Kaveri Sahkari Awas Samati is also having some entitlement of the constructed space, and the marketing agent. And the marketing agent is also not taking any money. Marketing agent has also some rights on the constructed space. So all the three collectively started booking, and they were actually receiving the booking amounts of their part of the entitlement of the space. So all the 3 started booking the flats, and however the project is one. So therefore the first of all, the NCLT admitted the application as like the establishing that there is a default, and then the directors challenged the NCLT order, arguing that there was no payment received in this company or the payment was received in the other company. So that issue actually came before the NCLAT. So developmental rights, marketing rights, ownership rights, all this was discussed in the judgment, which is Horizon Buildcon. Now, the tribunal held in this case that NCLT's decision to admit Section 7 application against the Horizon Buildcon Private Limited, emphasizing project-based CIRP, was also the tribunal found that the CIRP should focus solely on the specific project, where the maximizing assets for the creditors, and the dual CIRP should be started in this case. The dual argument like CIRP against was rejected as withdrawn. So that is something which is again clarified in this case, that the companies can actually go for the collective insolvency. Collective insolvency is also possible. That was also indicated in this case, but in another case, it was very clear that all the 3 companies can actually go for that. Something which was finally handled by NCLAT, and by referring to the Supreme. I will come to that judgment. So in this particular judgment, it was somehow this concept was touched. Before I go to that judgment, I will actually see the other judgment, which is in the case of Ashok Kriplani versus Ramanathan Bhuvaneshwari. Ramanathan Bhuvaneshwari is the RP, and the name of the corporate director is Dreams Infra India Limited. So in this case, this is a judgment of NCLAT Chennai, and in this case, in this particular case, there was the insolvency of the full case, and then the insolvency was shifted to a project insolvency. Then the RP was trying to claim his CIRP cost. So then NCLAT said that since the first insolvency was for the entire company, then the RP was also changed. Now the second insolvency is for the project insolvency. the RP is claiming the fee from the second insolvency. So there was no link. So this was another, there was another kind of focus that the project is a project. Even if the company is same, one project insolvency is a separate, second project insolvency is a separate, and RP has no right to claim the dues of the earlier insolvency from the second project insolvency. So this is also like kind of one focus on the project-wise CIRP cost. Because see, these are the difficulties, the project-wise CIRP cost. So it cannot be shifted to the other project. Then another judgment, which is from NCLT Delhi, that is in the case of Umesh Chandra versus GRJ Distributors and Developers Private Limited. The judgment is dated June 2023, 14th June 2023. It is from NCLT Delhi, and on this case, there is a project called Rosewood Project, and the home buyers in fact approached the NCLT for commencement of CIR. NCLT initiated the CIRP against the corporator, and the RP was appointed. And somehow there was some inconsistency in the order, so they filed a clarification. RP filed a clarification application whether the whether the project insolvency or it's a full insolvency, whether the moratorium is only on the project or on the full company. So that was a clarificatory application which was filed. So the NCLT clarified that it is only for one project, and it is further clarified that the moratorium imposed is limited to the project only. Limited to the project only, although practically difficult, but it was limited to the project only kind of a order passed. Now there is another company which is from NCLT Bangalore, again from the same group, Dreams Infra Private Limited, Dreams SNE Project Allottees Welfare Association, Dreams SNE Project Allottees Welfare Association versus Dreams Infra India Limited. The judgment is dated February 2023, and it is from NCLT Bangalore. In this particular case, the Allottee Welfare Association representing the home buyers filed an application under Section 7 for Dreams Infra India Limited. Now, this construction of the project, in fact, started 75. There are two projects. One is 70% complete, and the other is 20% complete. Now, despite the initiation, is confined to another project. The other two allottees, like Dreams Samudra and Dreams SNE, are also affected because they are supposed to contribute for the CIRP cost. So they assert the willingness to complete the project themselves. They wanted that they will complete the project themselves if necessary. So the completion of the Dreams SNE project will benefit a significant portion of the home buyers. So they submitted an application that they want to handle their insolvency separately because they are very close to completion of the construction. Then the NCLT, in fact, permitted the initiation of CIRP against the project and not the CD as a whole. However, the moratorium was completely declared. And in the entire order, there was no clarification whether the moratorium is on the project or on the entire company. So regarding moratorium, there are various judgments where the moratorium is considered to be limited to the project, where the moratorium is extended to the entire company. So these are some kind of controversial orders. Another judgment that I would like to see is the N. Kumar, who is the RP of Sheltrex Developers Private Limited versus Tata Capital Housing Finance Limited, and that judgment is in 25th of April 2022. That's from NCLT Chennai. So this was the application which was in fact rejected by NCLT. In fact, RP filed an application. RP said that the permission to initiate project-wise insolvency for the purpose of conducting reverse CIRP. Permit the RP to issue separate expression of interest for each project. Now, NCLT said that there is no concept of CIRP of a specific project under the law. And it cannot be triggered to put the corporate debtor back on its feet in the interest of unsecured creditors like allottees. Replaced management may carry out the real estate project as originally envisaged, and this is what the NCLAT said. The Umang Realtech cannot be applied to the instant case because the promoters have not put forward any fund which was there in the Umang Realtech. In that case, the promoters came forward, or promoters tied up with the JM Financial Corporation to bring in fund, and that fund would be considered as interim finance, and that fund would be used only for the completion of the project, and it will be handed over. So there is no such proposal in this case. The promoters are not coming forward. So it cannot be the Umang Realtech cannot be followed in this case. Therefore, that application was dismissed. So let us try to understand. I said last week that the reverse insolvency is slightly complicated. It is only possible in those cases where the construction is near completion, the funds are available or are tied up. That funds can be considered as interim finance. Funds will be used for completion of the project, and the handover to the allottees would be done within a reasonable time, most probably less than 330 days. And the RP will perform all these functions. Management will cooperate. This is what is called reverse insolvency. But simply like after the CIRP is initiated, RP going to the court and asking for the reverse insolvency or project-wise insolvency, promoters are not coming forward, funds are not tied up, that's not something. However, in one another case where the allottees said that we would like to complete our project ourselves, because they would present their project economics, they would say that no, we could, so therefore the insolvency of their project should not be started. So that is what is also possible. So the promoters should contribute, or the allottees separately. Association can confirm that yes, they would be able to complete the project. So the adjudicating authority must be satisfied. Yes, it is possible that the project can be completed by way of reverse insolvency, or the adjudicating authority must be satisfied that only this or this project are under default, so the other project should not suffer. So only the project-wise consultancy can be started. Now, I will now come to another case, which is Kotak Mahindra Bank Limited versus the resolution professional of Universal Buildwell Private Limited. The corporate debtor, Universal Buildwell Private Limited. The date of judgment is 23rd August 23, and it is from Justice Ashok Bhushan and Mr. Barun Mitra. Now, in this particular case, let us try to find out the facts. Universal Buildwell CIRP started for Universal Buildwell, and in fact, the application before NCLAT is to recall or modify or amend the order of commencement of CIRP, and like it should only for one project, which is Universal Aura project of the corporate debtor. That application was submitted before NCLAT. And it was also suggested that the IRP should be appointed only for the said project, and he should only invite claims for the said project, which is Universal Aura project. There also the resolution plan will also be invited for that project only. And the adjudicating authority, in fact, took the view that there is no provision available that under the adjudicating authority's review, and hence the application was rejected. Now, when this appellate authority looked into this fact, and the appellate authority also kind of confirmed that it is not possible in all the cases that we admit such request from home buyers. So the reasoning was not found acceptable. The CIRP has been initiated against the entire company, and the modification of that order is not possible. So by rejecting that application, the NCLAT said that we have not seen any error in that order. Now, as I was saying, the other concept of insolvency of a project, where the project is taken up by three companies, and the NCLAT New Delhi, in fact, ordered for the insolvency of all the three companies. Name of the case is Mist Avenue Private Limited versus Nitin Batra, and there are three corporate debtors in this case. One is Anand Info Edge Private Limited, Mist Avenue Private Limited, Mist Direct Sales Private Limited. Date of the judgment is 17th November 2023, and this is passed by none other than Chairman of NCLAT, Justice Ashok Bhushan and Mr. Barun Mitra. So in this judgment, Anand Info Edge in fact filed this appeal, and the Anand Info Edge was in fact allotted a land area of more than 1 lakh meters, and then entered into a collaboration agreement, and also entered into a kind of development agreement, and also entered into a sales agreement. So the adjudicating authority held that the application under Section 7 by Mr. Nitin Batra and others under are as maintainable. So this was a joint application filed against the Anand Info Edge, Mist Avenue and Direct Sales. Three respondents were there, and all the three appellants had joined hands to develop the project. And this is a real estate project, and the project cannot be successfully completed by any one of the applicant who are the respondents to Section 7 application. The Section 7 applications were filed collectively against three companies. One is the company where the land has been allotted. The second is the company where the collaboration agreement has been entered. And the third is the company where the direct sales agreement has been executed. Finally, in case NCLAT said that the project cannot be successfully completed, all three have to work together. Also, the court said that all the three are impleaded, and they are issuing allotment letters they are also issuing builder-buyer agreement. So the project name was Festive City. It was only one project. The name was common. So the payments were also received by all the three companies differently. So in fact, they relied upon the earlier cases of Edelweiss Asset Reconstruction Company versus Sachet Infrastructure Private Limited, and another case was Mrs. Mamatha versus AMB Infrabuild Private Limited, where it was clearly held that this consolidated insolvency resolution process can be initiated against one or more corporate debtor who have come together to develop a project. So there will be, in fact, now three judgments. One is this judgment of Anand Info Edge Private Limited. Another is the Edelweiss versus Sachet Infra, and the other is AMB Infra Builder, where in these cases the collective insolvency was started because the one or more or three companies, in fact, started developing a project collectively. So therefore, the insolvency of all the three collectively would resolve the project. So in fact, all the three judgments, in fact, they have taken the support of State Bank of India versus Videocon Industries Limited, where this entire group insolvency was defined. So this is the present scenario of the group insolvency or project insolvency. I'm not saying that this is a group insolvency. I'm actually saying that this is a project insolvency. So this should not be considered as a group insolvency. It should be considered as a project insolvency. So we have actually considered one, that even if a company is having multiple projects, one project can go into insolvency. Even if there are three companies handling one project, all the three companies can go to insolvency collectively together, resolving that project. Goel, and the question is, when a company goes in the CIRP, power of board are suspended. However, when only one project will go under CIRP, what will be the responsibilities of the directors of the company? Will RP will take charge or on it or not? So if one company, one project goes into insolvency, the powers of the board of directors will get suspended for that particular project, not for the other projects. RP will not take control and custody of the other projects. RP will only take control and custody of the project under insolvency. However, RP may require the control and custody of the total books of accounts to understand the assets and liabilities of each project so that he is able to segregate the assets and liabilities of that project which is under insolvency. RP will not take charge of all the other common assets. RP will take charge of the exclusive assets of that project. However, RP will monitor what are the common assets, and the common assets the RP will have the access to reach and access to monitor, but will not take control and custody of those assets. So that's what is my understanding about this question. Now I will go forward and I will ask this Swami Nageshwaran is asking, is it possible to apply the project-wise model in very old projects which are also not RERA registered, account books of the CD also not available? Yes. In real estate companies, the project is separately seen. All the inventory can be seen separately because it's a real estate project. The allottees can file their claim for that particular project and they can submit their documents, builder buyer agreement, the receipts. Even if the books of accounts are not available, it is easier to resolve a real estate case because see, the liabilities can be known from the claims and the assets are there at the site. Other than something which is a construction material, which is not really very high in value and also gets kind of spoiled or destroyed in case the construction is stopped for some time. So therefore, it is possible, even if the project is not RERA registered, the project-wise insolvency is possible in those cases also. Again, as Swami Nageshwaran says, further the CD is under liquidation. Now, if the CD is under liquidation, then we can even think of liquidation, sale of the corporate debtor as a going concern. Sale of the corporate debtor as a going concern, or sale of that project as a business. Because under regulation 32, in liquidation, a company is entitled to, the company RP, the liquidator can sell the piecemeal assets, assets in lump sum, business in lump sum, and company as a going concern. So this company as a going concern may not be possible in this case, but then the project as a business, one project as a business can be sold as a going concern if the company is under liquidation. Then Sanjay Gupta, my partner, is asking, can a creditor initiate CIRP of only one project, and can the order be passed by the adjudicating authority? Yes, the creditors also can apply for initiation of CIRP for one project. Like for a real estate project, we need 10% of the home buyers, or we need 100 of a particular project. That is a Section 7 application, which is, they are considered as unsecured financial creditors, and they can collectively file an application for CIRP commencement. However, in case that particular creditor is not a home buyer, is not an allottee, then he has to be a particular creditor who has specifically given a loan or have specifically given some material to a particular location, to a particular project. Then he can also say that, like, because see, as a financial creditor, somebody can say that I would start the insolvency of this project only, because then in that case, I will be considered as a secured financial creditor and the COC will not be cluttered, and I can apply for the insolvency of one project only, which I have funded. Similarly, an operational creditor can also say But for an operational creditor, I believe the company as a whole would be a better idea rather than going for particular project insolvency. However, for a lender, for a bank financing a one project, he would be beneficial because he will be controlling the larger voting share in a particular project-wise insolvency. Hari Prasad is asking a small clarification required in case of reverse CIRP at the request of the home buyers. What would be the role of COC? Will there be COC at all in such cases? Yes, there will be COC in the case of reverse insolvency also. There are cases where the COC has been constituted. There are cases which only under the RP, but I believe in most of the cases the COC has been constituted. In the case of reverse insolvency, the COC will not progress on the resolution process. The COC will not invite expression of interest. COC will not issue the will receive the resolution plans. COC will not put any resolution plan for voting. However, the COC will, along with the RP, will monitor the fund flow, will monitor the construction progress, and will also monitor whether the home buyer's claim have been paid or not. So that is the role of the COC in the case of reverse insolvency. One anonymous attendee is saying, I request you to share an update of Ansil's API's insolvency case. Ansil's API insolvency case presently is not under my focus. I would understand it, and I could not find that case which is relevant for project insolvency or even for reverse insolvency. Last week and this week, we are focusing on project insolvency and reverse insolvency. So Ansil API is not figuring out either as reverse insolvency or as project insolvency. Arpit Jain is asking where we find full recordings, sir. Is there any WhatsApp group release? What's the full recording of all our webinars are available on YouTube channel by the name of AAA Group. On AAA Group, all our recordings are available. It can be seen, it can be viewed, and you can subscribe also. Whenever you subscribe to a particular channel, you will get an alert that a new content has actually been uploaded. So the new content always be alerted to you in case you subscribe. So please do subscribe. Then we actually have a query from Varchitect. If in a project there are total 120 flats and only 50 allottees, what the minimum number required to file for CIRP? 50 allottees, so 10% of the allottees can file the CIRP, can CIRP. 10% or 100, whichever is lower. So here the 50 are the allottee, 10% is 5, so 5 allottee can file CIRP. Then DSR IRP is asking, if the project-wise insolvency fails, how to liquidate the single project? Single project also can be liquidated, as I was explaining. In case this project insolvency fails, that single project actually will become the liquidation estate. That project can be sold to anyone. The only confusion would be what are the rights of the unsecured financial creditors. I believe in the case of liquidation, also the rights of the allottees who have entered into a builder-buyer agreement, who have paid advance, they would have rights under the Transfer of Property Act, and those rights would not be kind of reversible. So anyone who will buy that project under the liquidation would complete, will give them the handover, will sell the unsold inventory, or would like to resolve in case there is a deficit, then he may take additional compensation from the home buyers to complete the construction. So that is also possible in case it goes into liquidation. Now it's the other question is from Run Jans, whether home buyer is a secured creditor. Presently, home buyer is unsecured financial creditor. However, the Supreme Court has held many times, NCLAT has held that the first priority be given to the completion of the project. And in some of the cases, additional contribution, additional cost has also been taken from the home buyers to complete the project because there is a deficit. Deficit is higher than the assets. Therefore, the additional contribution has also been taken from the home buyers to complete a project. However, so far, the home buyers are unsecured financial creditors. There is a proposal. In fact, I have given a recommendation because of my humble understanding that in case we have to resolve real estate cases, then we have to consider the landowners, we have to consider the lenders, secured lenders, and we have to consider the home buyers, as all three people collectively can resolve a case, and also the agencies which are having rights of cancellations of their agreements or cancellations of their approvals or permissions or licenses. So all these four entities, four persons: one, the regulatory authorities; number two, landowners; number three, the home buyers and lenders, secured lenders. They all should be part of a COC meeting, and they should have a voting right specifically for the real estate cases, and then only they can resolve it. Otherwise, home buyers are unsecured, so these lenders, the secured lenders, will always like the company to go to liquidation. Again, anonymous attendee is asking, who decides that a particular case project insolvency will be initiated and not of the entire company? Is it decided by the applicant or the adjudicating authority? The facts have to be given by the applicant. Adjudicating authority will see whether other projects are under default or not, how much percentage of the company's projects are under default, whether the projects other projects are marginally under default or can be resolved independently. So all these facts has to be produced by somebody, primarily promoters, and then the adjudicating authority can take a decision whether it is a suitable case for project insolvency or not. Abraham is asking, in liquidation, home allottees who are in possession, these assets do not form part of the liquidation estate. In such cases, can the home allottees make claims and be unsecured financial creditors? In liquidation, in case they have the possession, then they are not supposed to file their claim. However, in case they feel that they still have some outstanding from the company, maybe that there was a commitment to install some white goods in the flat that has not been done. There were some commitments for commencement of a swimming pool or common facilities or a clubhouse that has not been done. So even after taking the possession, they can file their claim that this company is still under obligation to provide us some, there is some pendency. So they can still file their claim for the remaining part of it. In case they have taken the possession, so they cannot say that our full amount, whatever we have paid, that is outstanding towards the company. So they can file their claim only for the remaining part of the obligation of the company. We have a question from Niranjan RS. Sir, as a home buyer, it is reflected in the books of account, but the RP has failed to include the claim amount. What to do, sir? In case the amount is reflected in the books of account, in case the documents are available, the claim should be admitted. In case the RP is not admitting the claim, he should give a rejection with complete reasons to be recorded in that rejection letter or a rejection order. Against that order, every home buyer has a right to appeal before the adjudicating authority. What is required? That there should be a complete reasoned order from the RP why the claim is not being accepted. All the documents has to be provided to RP. That is the duty of the claimant. In case the documents are not provided, then the RP will reject it. Otherwise, if the amount is appearing, the documents are available, then it should be admitted. Ranjan NS is asking, in a 1 crore flat, if the home buyer pays 5 lakhs as down payment, 60 lakh has been paid by home finance company, what would be the nature of their claim? Is it secured? So first of all, the home finance company is a separate person and the home buyer is a separate person. Home buyer has given 65 lakhs to the company. The claim of the home buyer will be 65 lakhs. to the RP. However, if there is a tripartite agreement between the corporate debtor and the home buyer and the home finance company, and that tripartite agreement also has a kind of a condition or terms that in case of default of payment by the home buyer, then the company is under obligation to hand over the possession to home finance company. Then the home finance company will file their claim to the corporate debtor, to the real estate company, but that would be as a kind of indemnity or as a corporate guarantee kind of claim. So that will be unsecured financial creditor. So home finance company will be unsecured financial creditor in case there is a tripartite agreement. However, in case there is no tripartite agreement, then the home finance company will not file their claim to the builder, and only claim will be filed by the allottee. That will be 5 plus 60, 65 lakhs. Swami Nageshwaran is asking that, continuing with the above, there are 2 projects and 60 pockets of home are not sold, but completion of the project is more than 80%. Also, the unsold flats are under the IT attachment. So what is the question that I couldn't understand? Like, there are 2 projects and 60 pockets of the homes are not sold, but completion of the project is more than 80%. The unsold flats are under IT attachment. So of course, the corporate insolvency resolution process will resolve this issue. Once this attachment is done, the IT department will also be considered as secured operational creditor. They will also submit their claim as secured operational creditor, yes. And after their claim is admitted, then the attachment would be considered as lifted or detached. Then the resolution can be found. Any person coming from outside will actually submit a resolution plan. The IT department will also get their claim based on the liquidation value. The home buyers will also get their properties after construction. So this is something which is not a difficult case. Attachment by income tax department is at the most, even if we see the rainbow paper, at the most it will be secured operational creditors. And it depends what is the liquidation value of the company, and accordingly they will also get their share. Kamendra Kumar Rajput is asking, how fraudulent transactions, forensic audit of a company be done in case of project insolvency? In most of the real estate, there is a division of fund. How this would be dealt? Now, in case we try to see this forensic audit for a project-wise insolvency, this is a real challenge. This question is really very, very important question. In the case of project insolvency, what kind of transaction audit or forensic audit would be conducted? It definitely should be restricted to the project, the money received from the allottees, the construction cost, and anything which is from the allotment side, from the asset side. If promoters have sold something undervalued, it is an undervalued transaction. If promoters have sold some of the flats showing undervaluation, that is also undervaluation, the section 45. If the creditors of this section, this project, are paid in priority, that is 43. If the funds of this project, loan taken on this project, money collected from the allottees are diverted, that's the section 66. So it is possible. In fact, when we asked a question to our chairman, the chairman in fact rightly answered, you have to do something first for the first time in life. And please don't hesitate that we should give and we should provide you regulation for everything. One, that your intention should be clear. Number 2, it should be completely transparent process. Number 3, it should be discussed with the stakeholders. Number 4, it should be completely beneficial to all. If these are the policies, these are the considerations in your mind, I think each and every kind of difficulty can be resolved. Mehraj Kumar is asking, of late allottees cannot form part of liquidation estate. Then how to resolve? Only those allottees are not forming part of the liquidation estate who have got the possession. All other allottees are still part of the liquidation processes. Again, the anonymous asking, is this possible for secured lenders to do SARFAESI action on units which are sold and possession given but not registered? Now, possession is given and the title is not yet registered. If the title is not registered, first of all, the lender will go to the builder that this is my claim and the registration should be done in my name, and that is what is a tripartite agreement. So in case tripartite agreement is also not available, then I believe the unit number is identified. The builder, in case cooperating, then the SARFAESI action can be invoked. Maybe DRT permission would be required and the builder's cooperation would be required. But it is a difficult scenario that the possession is given, but the registration is not done. Once the registration is not done, that also probably means that the ownership of the particular property is not with the borrower. If the ownership is not with the borrower, what is the mortgage? If what can be the transaction recorded by CERSEI, Central Registry, because the asset is still not owned by the lender. So therefore, most of the home loan companies are entering into a tripartite agreement that the builder will give possession to the home loan company and then they will sell it. Menon, to be very precise, this development made IBC outside the purview. Couldn't understand the question. Again, Ranjan is asking, NOC is pending from authority and registration also, but possession is given and some are residing and some are not. Is it advisable to file claim? As I said, that if the possession is given, registration is not given, you should not file the claim. You should only file the claim for the remaining obligation of the company towards you. You should be there, but you should always say that I have got the possession, my flat is with me, so that in case the company goes into liquidation, you are safe. So the claim must be filed in case you still feel that some of the obligations of the company as contracted as per the builder-buyer agreement is still outstanding. Only for that particular estimated amount, the claim should be filed. So in fact, various questions, and I have taken up all the questions. And if there is anyone who would like to say something, in fact, we have already crossed our 1 hour limit. So it's wonderful, really very, very good question answer session. So we are now clear about the reverse insolvency, project-wise insolvency, and in case the project is collectively taken up by 2 or 3 companies, then the group insolvency of real estate companies, where all the 3 or 4 companies or 2 companies are collectively handling one project. Thank you very much. This is our way of learning. Be connected, and in case possible, subscribe to our YouTube channel so that the alert comes to you whenever a new video is uploaded. YouTube channel is AAA Group on the YouTube. Thank you very much. Thanks a lot.